Okay, Chapter 3, we are going to talk about tort law and reform. The PowerPoint for this chapter is 83 slides, so I am not going to follow that PowerPoint per slide because I can't even imagine how long my video lecture would be. So anyway, I've highlighted some items throughout the chapter that I want to speak to, and you're welcome at any point to email me and we can have a conversation or email back and forth questions to clarify things. So here we go, Chapter 3. So tort is a civil wrong which court provides a remedy in the form of compensation for damages suffered. Emphasis on negligence in healthcare settings is what this chapter is going to really focus on. And so there's two main differences between intentional torts and negligent. First is intent. So that's important to know. The act must be committed intentionally, and the wrongdoer must realize to a substantial certainty that harm would result. Although a negligent wrong may simply be the failure to act when there is a legal duty to act. This comes into play with any licensed professional, whether it is a nurse, a doctor, a dentist, a physical therapist, a respiratory therapist, radiology tech. There's so many folks in healthcare that are actually licensed, but this has to do with all of them. So on page 34 in the book, Objectives of Tort Law. Basic objectives are listed: preservation of peace, determining fault, deterrence from discouraging the wrongdoer from committing future acts, and compensations for the persons injured. The court must determine who should bear the cost of the unfavorable outcome. Is this the patient's fault or is this the provider's fault? And many of us have professional liability insurance, and it helps to a certain extent, but seriously, just as the book states, our biggest fear is that someone sues us for more than what our professional liability covers. Does that mean that, somebody can take my home? Does that mean I'm going to have to make payments for the rest of my life because I gave the wrong medicine or because I didn't do something as a nurse? So this is real life. This is what we learn about this, and we carry this with us and do our best to avoid this. All of what's in chapter 3. We do not want to be negligent. We do not want to divert from the standard of care. We do not want to unintentionally breach our duty. We don't want to cause any injury, etc. So anyway, this is a great chapter, but it's big. And that PowerPoint, 83 pages. Okay. All right. So I'm back to page 34 in the book. Negligence is a tort, a civil or personal wrong. Negligence is carelessness of a professional person, and what they're referencing is those of us who are licensed. So a nurse practitioner, pharmacist, nurse, physical therapist, pharmacist. I mean, the list just goes on. There's so many licensed professionals. I'm sorry, let me go back to that sentence. Negligence or carelessness of a professional person is referred to as malpractice, whereas criminal negligence is the reckless disregard for safety of another. And let me keep reading. It will explain itself better throughout the chapter. So review the differences between the commission of an act and the omission of an act, because there's differences there. Not all errors in medical diagnosis and treatments are considered to be malpractice. It's actually the responsibility of the treating professional to inform their patient about inherent risks. So there are some risks. For example, you know that it's a risk when you take pain medicine. You can't drive, you can't operate heavy equipment, machinery, make informed decisions. Also, another inherent risk that they're speaking of, for example, is it's known that like medicines like Benadryl causes dementia. That's just a known side effect of that drug. So if we choose to take Benadryl for allergies, then we know that that's just an informed risk. That is something that is a side effect. It's in the pamphlet. A patient may not read that pamphlet, but the information is there. Okay, so forms of negligence, figure 32 does a great job. Also, the paragraph on the bottom right hand side, page of 34, that describes all of those. Degrees of negligence is also mentioned: slight, ordinary, gross negligence. There are differences. Elements of negligence on page 35 also go into duty of care, breach of duty, injury, and causation. I'm not going to read those to you, but these pages have is so much information, good information. You can review those. That goes all the way. The elements of negligence start on page 35 and end on page 40. And then it jumps into summary cases. Okay, but let me go back to page 36 and things I highlighted as I was reviewing myself. Standard of care describes what conduct is expected. So if there is ever a lawsuit, or even before it gets to like a criminal, civil trial, whatever, they use standards of care, and they use eyewitnesses, or not witnesses. Hang on. Let me read this real quick. The courts often will rely on the testimony of an expert witness. That's what I was trying to say. Someone who's in the field. What is the standard of care? Is it normal to restrain a patient and not look at them for 6 hours? Absolutely not. As an expert witness, I could testify that our hospital has policy. We are to look at that patient every hour and document that we did and offer nutrition, body care, etc. every 2 hours. That's just policy. So I could be an expert witness when it comes to that scenario. Standard of care is conduct is expected of a person in a given situation. The general standard of acceptable care is based on a reasonably prudent person, what they would or would not do. So keep that in mind. The book on page 36 continues to give examples of failure to treat emergency department patient. That's actually a great story to read. Statutes are pretty important when it comes to tort and reform. Policies, duties created by policies, duty to hire competent employees. That is definitely a duty of all healthcare institutions. I'm going to say you have to hire competent employees. And even as I work as a nurse, and it's my responsibility as the employee to update my license and provide that information. I also have to update my CPR and different credentials. Oh my goodness. Credentials every year, every 2 years. That becomes my responsibility. But you got to have competent employees, or else you're going to be spending a lot of time learning about the different laws. Page 37 goes into the breach of duty. That is a failure to conform to or the departure from a required duty owned to a person. So when I'm going to talk about nursing just because that's what I am. I took an oath. When I graduated school, I took an oath and promised. It's actually the Nightingale Pledge if you want to look that up. So if I were to ever breach that promise or breach my duty, whether I'm at work or not, I owe something to society because I am a registered nurse, then I can get in trouble for that. So continue reading. Page 38 talks about failure to provide a safe environment. That's an interesting little paragraph. Responsibility to protect a patient. Absolutely, that is for all of us. Even honestly, from the CEO to janitors, it's all of our responsibility in healthcare to make sure a patient is protected. Injury is mentioned on page 38, then causation is on 39, and just I encourage you to read this entire chapter. The negligent misreading of a CT scan is important to know when it comes to tort and law. The summary cases on page 40 that start, please read those. Just interesting information there. Now, those of us, I am one, who appreciates a good medical drama on TV. Some of this will come, you've seen this, you've watched it on television. It's not always accurate on television, but that's okay. You get the idea, and then to read it in this chapter just validates. But you're not, let me stop right there. You're not quizzed or tested on medical dramas. You're going to want to read this chapter to get that information for quizzes and tests and objectives for this course, obviously. Page 42, intentional torts. Those are committed deliberately. This is rare, but it does happen. Not every healthcare professional has great intentions, unfortunately. Please, understand the difference between assault and battery. Battery is the intentional touching of another person in a socially impermissible manner, where assault is a little more blurry, I guess, is a good definition. So read that. Page 44, false imprisonment. Here we talk about, I mentioned the restraint policy earlier, the restraint use. You cannot restrain a patient without having a good reason, without having a doctor's order, and following up on that patient every hour. Some facilities, and depending on what type of restraint, it might even be every 15 minutes. And by the way, in a hospital, you have to renew that order for the restraint every 24 hours. So you can't just restrain somebody for convenience. It really has to, you have to show cause that you're protecting the patient from themselves. And tons of different reasons why we use restraints, but most importantly, we want to protect the person. It has nothing to do with convenience, or it shouldn't. Page 44 goes into contagious diseases restraints. So defamation of character is something that plays into healthcare. Slander is verbal and libel is written, so you have to be very careful. With social media, you have to be very careful with online reviews. If you put something in writing that is not accurate regarding a healthcare provider or a local hospital system, they could actually sue you. I've even seen this as extreme as local restaurants and boutiques, where the law allows the boutique owner or restaurant owner to sue the person who wrote that type of review. So know the difference between slander and libel. All right, flipping the page, 46, just more examples. Read through those. 47, 48 talks about fraud. Fraud is defined as willful and intentional misrepresentation that could cause harm or loss to a person or property. Fraud is very broad in healthcare. Fraud can be you can commit fraud when you're speaking to a patient. You can commit fraud financially. You can commit fraud with documents. So that's very broad. Invasion of privacy. Privacy on page 48. This is a huge issue in healthcare because it is part of our constitutional rights. We should have privacy. And HIPAA is the I'm going to get it wrong. Health Information Portability Privacy Act. So even if you are a hospital or medical office employee, if you jump on an elevator and you speak of patient A, and there's other people in this elevator or even in the cafeteria, we'll use a different setting as an example. If you're speaking of this person and giving out enough detail, if they're family members on that elevator with you, or if the family members in the cafeteria and can hear you talking, you're breaking the federal law when it comes to privacy. Our patients who come to offices, diagnostic testing, or hospital for care, they have a right to privacy. So be careful how you guard information like that. Even you can get in trouble legally if you walk away from your work computer and leave it open and somebody else logs on, or not even logs on, but uses your sign-on to look up patient information, whether it's family member themselves or somebody in the lobby. If they're not supposed to see that and you've walked away from your computer station, then you're held responsible because you were the one signed on. And that type of stuff is tracked, by the way, by the IT departments. Okay, page 49, intentional infliction of mental distress. That is important. Well, all of this is important, but I have that highlighted. What that means. Mother shown her premature infant. That's an interesting little paragraph there on page 49. Products of liability. We're going to wrap up this chapter talking about that. This is the accountability of a manufacturer, seller, or supplier to a buyer or a third party for injuries sustained because of a defect in a product. So I automatically, my brain goes to such things as recalls, like with the child products, whether it's car seats, cribs, toys. Oftentimes our grocery stores will recall certain lettuces, certain fruits, certain meats because of a defect in the product. But this also happens in healthcare. So if you've watched the TV in the last 2 to 3 years, maybe you've seen commercials about mesh products that were used in hernia repairs. That is a real thing. They found a defect in that mesh product that was sold by these pharmaceutical representatives for many, many years to physicians and surgeons, with the intention that they would work and hold that hernia in place a lot longer than without the mesh. But now there's all sorts of recalls, and if you are a late night TV watcher, you'll see lots of medical injury lawyers soliciting for different things, whether it is surgeries or certain medications that a person took. This is what products of liability speak to. Page 50 starts talking about negligence for these type of liabilities. There's a paragraph about tainted Tylenol capsules. That is a real thing. Breach of warranty, strict liability. And that is the end of the chapter, and whoa, that's just a lot to talk about. This video is a little bit long, and anyway, so review the chapter. Please outreach me if you have any questions. I am here to clarify, and I could just share stories all day. So I'm going to stop talking. Please let me know if you have any questions. Thanks.